There is one signature that has cost more retirees their entire savings than every scam I have ever litigated, every fraud I have ever prosecuted, and every courtroom theft I have ever seen combined. It is not a stranger's signature. It is not forged. It is not coerced. It is the retiree's own signature, given freely, on a one-page form their bank handed them across the counter. The form adds a child as joint owner of the retirement account. The retiree believes they are making things easier for the future. They are not. They are giving away legal control of every dollar that will ever land in that account, and the law of every state I practice in supports that transfer of control completely. My name is Michael Reed. I have been an elder law and family attorney for 20 years. I have represented over 400 clients in cases of inheritance disputes, financial abuse, and elder fraud. I chose this work after watching my own grandmother lose her home to her stepchildren the year I started law school. I sat at her kitchen table in upstate New York and could not tell her there was anything I could do. That was the last time I felt helpless in a legal situation involving someone in my own family. I made sure of it. In the last 6 years alone, I have personally handled 60 cases where a retiree's own child legally drained their parents' retirement account. Not stole. Drained. There is a difference between those two words, and that difference is the entire reason I am making this video. If you are over 60, you need to hear what I'm about to say. If you have a parent over 60, you need to hear it on their behalf and have the conversation with them tonight, not next week. I want to tell you about Margaret. That is not her real name. She is 73 years old. She raised 2 children largely on her own after her husband Edward died of a heart attack in 2015. Edward had been the financial planner of the family. He paid the bills. He balanced the checkbook. He filed the taxes. Margaret learned all of that for the first time at 63 years old, sitting at the kitchen table the week after the funeral with a stack of bank statements and a yellow legal pad. She figured it out. She is one of the most capable, methodical, careful people I have ever met. I want you to picture this woman because the picture matters. She wears reading glasses on a chain. She brings her own pen to every appointment. She writes down what I tell her in a small spiral notebook because she does not trust her memory the way she once did, and she does not pretend otherwise. She spent 34 years working as an administrative manager at a public school district office. She kept folders. She kept dates. She kept every receipt for over a decade. When she walked into my office in January of last year, she had a binder of statements organized by month going back to 2018 and a separate folder of tax returns going back to 2009. Margaret was the kind of client an estate attorney respects on site. What happened to her was not the result of carelessness. It was not the result of a bad choice in a moment of weakness. It was the result of a single decision made in a moment of trust with a person who at the time of the decision was completely deserving of that trust, and it cost her $84,000 in 9 days. Margaret has 2 adult children, a daughter, Susan, who lives 20 minutes from her mother, and a son, Kevin, who lives 4 hours away in another state. Kevin is the younger child. He is 45 years old. He works in commercial real estate and has done well at it for most of his adult life. When Edward died, Susan was the one physically present. She brought meals. She handled the funeral arrangements. She sat with Margaret through the worst of the grief. Kevin came for the funeral, called twice a week for the first year, and slowly returned to the rhythm of his own life 4 hours away. That is not a criticism of Kevin. That is just the reality of distance and adult life. In January of 2018, 3 years after Edward's death, Kevin came home for Margaret's 70th birthday. He brought his wife and their daughter. They stayed for the weekend. On Sunday morning over breakfast, Kevin raised something he had been thinking about for months. He said he was worried about the distance between them. He said if anything happened to Margaret, if she had a fall, if she was hospitalized, he would have to fly in and he would have no way to handle her finances quickly. He suggested adding himself to her checking account as a joint owner, just in case. Just so that if something happened, he could pay her bills, fill her prescriptions, handle anything administrative, without having to wait for power of attorney paperwork to be processed during a crisis. Susan was at the table when this conversation happened. Margaret asked Susan what she thought. Susan said it made sense. Susan was already a co-signer on Margaret's safety deposit box. She had no concern about Kevin being on the checking account. They were family. 2 days later, on a Tuesday morning in February of 2018, Margaret drove to her local branch with Kevin on the phone for verification. She signed a one-page form that the teller printed out at the counter. The form had 10 lines on it. It said at the top that the requested action was to add a joint owner to the existing account. It listed Kevin's name, his date of birth, his social security number. Margaret signed at the bottom. The teller stamped it. The whole process took 11 minutes. When she walked out of the bank, Kevin was a co-owner of the account where her social security checks were deposited. He had equal legal rights to every dollar in the account from that point forward. He could move funds, write checks, transfer to any other account he chose, without ever notifying Margaret. The bank did not need her permission to honor any of his requests. He was, legally, an owner of the account in exactly the same way she was. Margaret did not know any of that. She thought she had given him an emergency access key. What she had given him was a co-equal claim on her retirement. For nearly 7 years, the arrangement worked exactly as she had imagined it would. Kevin checked in monthly. He never moved money. He never asked for anything. He never even logged into the account. He was busy. He had his own job, his own income, his own life. The account sat in the back of his mind as an emergency option he hoped he would never need. And then, in November of 2024, the life he had built started to come apart. Kevin's wife had moved out of their house in October of 2024. By November, the divorce had become contested over assets and over their 9-year-old daughter's custody schedule. Kevin's divorce attorney needed a retainer of $15,000 to take the case. Kevin's lease on his current apartment was ending in December. He needed first month, last month, and security on a new place, total of $9,000. He needed to put his daughter in summer programs his soon-to-be ex-wife had insisted on, requiring $3,000 in deposits. He had been carrying credit card debt of $11,000 that the consolidated payoff had come due on. He had been in financial trouble for 18 months, and Margaret never knew. Kevin had not told her. He had not told Susan. He had not told anyone. Men of his generation in his profession, he told me later, sitting across from me in this office, do not call their mothers to discuss financial difficulty. They handle it themselves. On a Sunday night, December 1st of 2024, Kevin opened his banking app for a routine check. He saw in the list of accounts associated with his name the joint checking account he had not used in nearly 7 years. He had never logged in. He had never even glanced at the balance. He logged in for the first time. He saw a balance of just over $87,000. He sat with that number for several minutes. He told me later that he did not start out planning to take all of it. He told me he started out planning to take $15,000 for the retainer and tell his mother about it within a week. And then he opened the transfer screen. Day 1, $9,600 to his personal checking account. He typed the description himself, a single word, personal. Day 2, $11,200. Description, loan. Day 3, $14,500. No description. Day 5, $13,000. Day 7, $19,500. Day 9, $16,200. Total over 9 days, $84,000. Margaret's entire emergency fund, her Social Security accumulation, the proceeds of Edward's life insurance that she had been letting sit untouched for the last 8 years. All of it. Margaret first noticed something was wrong on day 12, when she logged in to pay her quarterly homeowner's insurance bill, $2,300. The payment was declined. She thought it was a system error. She called the insurance company. The insurance company told her the payment had been declined for insufficient funds. She called the bank. The agent on the phone confirmed her balance, $487. She thought there had to be a mistake. She drove to the branch. The teller at the branch pulled up her account. Margaret watched the screen turn around. 6 large outgoing transfers to an account titled in Kevin's name, all in the previous 12 days. She told me later that her first thought was that Kevin's account had been hacked, that someone was using his identity to drain her money. She asked the teller, very calmly, whether the bank could reverse the transfers immediately because she suspected fraud. The teller called over the branch manager. The branch manager pulled up the account ownership record. He looked at Margaret. He told her, gently and professionally, and with what I have no doubt was real regret in his voice, that there was no fraud. That Kevin was a legal joint owner of the account, with equal rights to the funds, and that the transfers he had made were authorized transactions under the account agreement she had signed in 2018. The bank had no legal authority to reverse them. She would need to take the matter up with her son. Margaret called Kevin from her car in the bank parking lot. He answered on the second ring. He cried. He said he was so sorry, Mom, that he had been planning to put it back, that he had been waiting for the divorce settlement to clear so he could replace what he had taken. He said he had not seen any other way. He had not wanted her to know. He had not wanted her to worry. Margaret asked him very quietly whether the money was still in his account. Kevin said most of it was gone already. The retainer, the new lease, the daughter's deposits, the credit cards. He said he had $21,000 left. Margaret hung up the phone and sat in the car for 47 minutes before she felt steady enough to drive home. She did not call Susan that day. She did not call me that day. She drove home, made a cup of tea, and sat in the kitchen Edward had built for her in 1979 and tried to think about what to do. She came to my office 2 weeks later, in January, after Susan finally pushed her to talk to a lawyer. If you are watching this right now and you have a child as joint owner on the account where your retirement is deposited, please pause this video and subscribe before you watch the rest. What I am about to tell you about what the law could and could not do for Margaret matters more than I can express in a single sentence. And if you have a parent over 60 who has done this same thing at any point in their life, send them this video before you have any other conversation with them about this topic. The next 10 minutes could decide whether they keep their savings. Here is what the legal system offered Margaret. The bank had committed no violation. No fraud had occurred. Kevin had broken no law. Joint accounts in the United States, with right of survivorship, are governed by a doctrine called joint tenancy. Under that doctrine, during the lifetime of both account holders, either holder can transact independently and unilaterally. The bank cannot and does not need to ask one owner whether the other approves a transfer. That is by design. The whole point of joint accounts under that doctrine is to allow either holder to act without the other's involvement. The bank had behaved exactly as the law required. Margaret could file a civil suit against Kevin for conversion. Conversion is the legal term for taking property that you have a contested claim to. It is the closest thing to theft that applies between joint owners. I explained to her what filing that suit would mean. The cost would be between $15,000 and $30,000 in legal fees. The time would be between 2 and 4 years. The outcome depended entirely on whether Kevin still had assets to satisfy a judgment when the judgment came down. Kevin had spent $31,000 on the divorce attorney, $20,000 on the new apartment, the deposits, the daughter's expenses, $12,000 on past credit card debt. He had $21,000 left at the moment Margaret discovered what had happened. By the time we filed, served, took depositions, and proceeded to judgment, that $21,000 would almost certainly be gone too. Margaret's options were these: spend money she did not have to chase money he no longer had, or write off $84,000 and decide what to do about the next decade of her life with the savings she had left, which were the equity in her home and a partial pension that paid her $1,400 a month. She wrote it off. She sold the house in February. She moved into a one-bedroom apartment in the same town, near Susan. She is 63 years old in spirit and 73 years old in body, and she will be working part-time at the school district she retired from for at least the next 4 years to make her current finances work. That is the case. That is the entire arc of what happened to Margaret because of a single decision made in 2018 in 11 minutes at a bank counter. I want to give you 4 rules. They are the 4 rules I now give every client over the age of 60 in their first meeting at this office. I have been giving Margaret's case as the example for these rules ever since she walked out of here in February. Rule 1. The account where your retirement deposits land has one name on it. Yours. Not your child's, not your spouse's, not your sister's, not your trusted friends. Yours alone. If someone needs to help you pay bills or move money on your behalf, they receive limited authorization, never joint ownership. A joint owner has equal legal rights to the funds. A joint owner can drain the entire account without your knowledge, and the bank cannot stop it. There is no convenience that outweighs that exposure. Rule 2. Every authorization you give has a written limit. If you allow someone to move money on your behalf, the limit is on paper. Per month, per transaction, per category. Helping with the bills is not a limit. Helping with the bills is an invitation. Without written limits, every movement is authorized by default. The phrase, "your attorney needs to see in your file," is Monthly disbursement authority not to exceed $1,500 for utility, medical, and pharmacy categories. Specific, capped, categorized. Rule 3. Your account statement goes to a third person you trust, not to you, not to whoever helps you, to a third party, another adult child, a sibling, a close friend, your attorney, monthly, in paper or by separate email. The person who moves your money can never be the same person who reviews the statement. Margaret had no third reviewer. Kevin was both the helper and the only other person who could see what was happening in the account. By the time Margaret looked at the account herself, 12 days had passed and the money was gone. If a sibling or a daughter had been receiving statements in real time, the first transfer would have been flagged before the second one happened. Rule 3 is the rule that protects you even if you ever break Rule 1 or Rule 2. It is the most important rule in this entire list. Rule 4. Any transaction above a threshold you set requires you to be physically present at the bank. Pick a number, 1/4 of your monthly retirement income. Any transfer or withdrawal above that, the bank only executes with you in person at the branch. Not by app, not by online portal, not by phone, only in person. This service exists at every major American bank. It is called an in-branch authorization requirement, or sometimes a positive pay restriction. 90% of the clients I see for the first time have never been told this option is available. Walk into your branch, ask for it specifically, set the threshold, get it confirmed in writing. There are also 3 things you must never do, and I want you to write them down or pause the video and take a screenshot of this part. Never add a child or anyone else as joint owner of your retirement account, even temporarily, even for emergencies, even because the bank teller suggests it would be easier. The law does not give the bank a way to undo the damage if the joint owner ever decides to act. Never allow notifications or statements from your retirement account to be redirected to anyone else's phone or email address. Once those notifications go elsewhere, you have no early warning system, and the warning system is the only thing that catches a problem in time. Never give a person access to your account without a written limit on what they can do. If your bank tells you that they cannot put a limit on a joint owner, your bank is telling you the truth. That is exactly the reason joint ownership is the wrong tool, no matter what your child or your sibling or your friend says they need it for. I want to close by telling you why I keep making these videos. I sit with someone like Margaret in this office every single month. The names change, the amounts change. Sometimes it is a son, sometimes a daughter, sometimes a stepchild, sometimes a sibling. The mechanism is identical every single time. A joint signature given in a moment of trust. A child whose own life eventually has a crisis the way every life eventually does. An account that is no longer legally yours alone. And a bank that has no authority to protect what you signed away. The intervention that works happens before the signature. Not after it, not during it, before. If you are over 60, or if you have a parent over 60, share this video with them tonight. Send these 4 rules. Insist that they be applied. Because the case I described to you today did not happen because Margaret was careless. It did not happen because she trusted the wrong person. Kevin, on the day Margaret walked into the bank in February of 2018, was completely deserving of her trust. The case happened because no one told her these 4 rules before she signed that 1-page form, and because 7 years later, his life had a crisis the way every life eventually does, and there was nothing in place to protect her from him on the day he opened that app. I have made this video because the only protection that ever works in this kind of case is the protection that exists before anyone signs anything. After the signature, the law has almost nothing to offer that is worth what it costs to chase. Thank you for watching this. Thank you for staying until the end. I will keep making these videos as long as the cases keep coming through my door. And every time someone applies these 4 rules before they walk into a bank, that is one more retirement that does not end the way Margaret's almost ended.